Good morning and welcome to our 10 a.m. program this morning, Eastern Energy Expo 2020 on demand. This morning we're taking a little bit of a different turn. Last week we talked about how the government was looking to put us out of business because we're in the petroleum business. So we talked about carbon policies in the various northeastern states. We talked about the Transportation and Climate Initiative. We spent a lot of time in this industry in the past 18 months talking about the electrification of everything and how that has taken a lot of time of, the trade associations representing you as distributors. Today, we're going to talk about everything else you need to know as an employer that could also put you out of business if you don't do it properly. There have been a lot of changes to employment law. And while there are various wrinkles state by state, the overall theme of what is happening in the employment law silo in this part of the country is there is a great deal of commonality. And this morning we are blessed to have two individuals that know this front and back. They handle it from both a business advisory consulting perspective, making sure you stay out of trouble, and then from a litigation perspective, once you might get in trouble by running afoul of the all of the little nuances that we might not be up to speed on, and that's the purpose of today. So our two presenters are Angela Middleton. Angela is an associate at the law firm Saul Ewing, Arnstein and Lair, a large regional law firm here, and for the record, Saul Ewing, Arnstein and Lair are counsel to the Fuel Merchants Association of New Jersey, as well as counsel to many of our members individually. Angela Middleton focuses on commercial litigation for corporate clients, focusing primarily in insurance and higher education. Her experience includes matters involving excess and catastrophic loss, professional liability, and general litigation. She worked for the Philadelphia District Attorney's Office and the Camden County Prosecutor's Office. The services Ruth provides are employment benefits, ERISA litigation, commercial litigation, and employment litigation. Ruth Rawls is a partner at Saul Ewing and concentrates her practice on complex commercial litigation, employment litigation, real estate, and litigation involving closely held corporations. She has extensive experience litigating matters at the triad and appellate levels in both state and federal courts in New York and New Jersey, as well as in private mediations and arbitrations. She's litigated claims arising under the New Jersey Consumer Fraud Act, the New Jersey Law Against Discrimination, and various other federal, state, statutory, and common law causes of action. And Ruth has probably the best list of things a lawyer could ever work on in her life, because Ruth's practice is focused on food, beverage, agribusiness, craft brewery, craft distillery, winery services, and cannabis law. So that is what Ruth Rawls does for work. I can only imagine what Ruth does for fun. Without any further ado, ladies, the floor is yours. And I am going off screen, but I will be here to monitor questions. Housekeeping, everyone, please make sure to use the question function and I will transmit the question. Ladies, the floor is yours.
All right, there we go. Well, thank you guys for joining us today. My name is Ruth Rawls, and I appreciate the kind introduction, Eric. What I do at work, unfortunately, is way more fun than what I do in my off time, which is pretty much laundry and dishes these days. So for those of you joining us in your newly renovated home offices, welcome. What we're going to cover today is kind of changes to state and federal law, what you didn't know that you need to know. And we're going to, and when originally we had talked about doing this in just two phases, and Angela, if you can go to the next slide. We talked about just doing federal law and state law, and then this whole pandemic thing happened. So we thought, hey, let's throw some COVID-19 in here as well, and address that in the context of how these laws change. So I'm going to talk today just about some state law updates so that you all are aware of what they are. We've tried to, you can go to the next slide, focus on the states that we know are at play here. There's a lot of information in the slideshow. We don't want to just read it to you. So we may kind of go through some of it quickly, but it's there for your reference if you need to go back to it. But really, we just want to put things on everybody's radar, things we should be looking at and focusing on. And then Andrew's going to take you through some changes on the federal side, and then we'll get into the topic that we are all so tired of talking about, COVID-19, which is not going away anytime soon and keeps changing employment laws and everything else that we're dealing with on a daily basis. So what I'm going to talk about is kind of I tried to make a big four list of things that I think are kind of important. I practice mostly in New Jersey, also in New York, but the things that have popped up where I know I'm constantly on the phone with clients saying, hey, we got to pay attention to this. Oh, this is an issue. We need to look at this. Make sure that you revise your handbook. So on my list, I came up with pay equity, cannabis, paid sick leave, and misclassification. And we've labeled that misclassification 1 because Angela is going to address misclassification 2 because it really pops up in 2 situations. And I'm going to focus on the independent contractor side. So with that, let's go ahead and get started. So pay equity, right? We can go into the next slide. So what is pay equity? What has happened in a lot of the state laws that I'm going to talk about here are in the absence of federal action, states have acted. And what that means is we have a patchwork of state laws that we kind of have to pay attention to and keep track of and make sure we're doing what we're supposed to. So pay equity is one of those places where we've heard a lot about it, we've seen a lot about it, but we haven't seen a lot of action on the federal level. So the states have said, hey, we're going to do what we're going to do. So the purpose of these laws are to prohibit employers from discriminating on the basis of gender or ethnicity or a protected class, depending on what state you're in, and the payment of wages. So what they all typically have in common is that they generally make it unlawful for an employer to intentionally pay employees in different protected classes, different rates of pay for the same work. That seems simple, but every single word that I said there has a different definition and meaning, and will affect what that means when you're talking about similar or same pay for similar, substantially similar work. So what is similar work? It's work that requires equal skill, effort, responsibility, and under similar working conditions. All of those things are fact specific. So it's sometimes a little difficult to understand what your obligations are, but that's what we're looking at. And a lot of these pay equity laws will also include a component that I'll talk about in just a minute on banning pay history. And we can go to the next slide. So what is pay history? Salary bans or banning pay history questions or salary questions like that. We hear a lot about those when we're talking about the wage gap, the gender wage gap, things are going on out there. So the purpose and rationale of this piece as it fits into the paid equity puzzle or the pay equity puzzle is that when an employer uses prior salary history to make compensation and hiring decisions, it perpetuates this historical pay gap or these pay inequities that have consistently existed throughout someone's career. So when I sit down and I'm being interviewed and someone asks me, how much did you get paid at your last job? And I give them that number, they're most likely going to set my pay scale similar to that. And the rationale behind these laws is, well, that's artificially depressed based on your membership in a protected class or your gender. So using a prior history to set your current salary isn't really the most effective way, and really it should be position dependent. So what do these laws do? What these laws typically do is they prohibit employers from inquiring about an applicant's prior wage or benefit during the pre-employment process or considering that information. So first and foremost, if you have an application that asks somebody for what they got paid before, we typically remove those. We can ask people, what would you like to be paid? What are you looking for? But we don't want them to provide us with the background on what they were paid at their previous position because it could run afoul of some of these laws. So let's talk just a little bit about the states that we focused on here, just to give you an idea. So if we can go to the next slide. Again, we tried to pull from the states that we talked to Eric about where we're most concerned in terms of the audience and looking at those: New York, New Jersey, Pennsylvania. For anybody that's in New York, New Jersey, you know, we have pay equity laws on the books. They are similar. So you need to be aware of them. I will tell you, New Jersey's pay equity law was an amendment to the New Jersey law against discrimination. So it does not just apply to gender, it applies to protected classes. They use phrases like substantially similar work. The geography is going to be important. In some states, it's just within the state of New York. In New Jersey, it's any location throughout the country. So they're not really taking into account geographical pay differences that may be relevant. Pennsylvania, what we've seen is action on Philadelphia side, the city, not on the state, and there's been some litigation out of that. But Philadelphia, if you have employees in Philadelphia, is something that you need to be aware of. You can go to the next slide. Other states that we looked at, Delaware, Maryland, and Connecticut, again, as you can see, they all have some form of a pay equity law in place in terms of how you pay employees and what you can pay employees. With respect to salary history bands, we can go to the next slide. We also put together kind of a list of those states in terms of what you can ask and when you can ask it. And you can see, again, most of the states that we're talking about here, New York, New Jersey, Philadelphia, even though it's not a state, Pennsylvania, Delaware, Maryland, and Connecticut usually have some type of pay history band. So with respect to pay equity, the thing that I would encourage you to do in dealing with it is, if you haven't done a pay audit, that's a really good and effective tool to figure out if you have an issue. Because in this area, we see, I call it creep, right? So salaries creep up over time. People get increases for this, increases for that. It may not be uniform across the board. And what may have been a level playing field at some point has started to separate somewhere along the line. So doing a pay audit and looking at the positions, the experience, and what folks are paid is a really good way to figure out if it's an issue that you need to look at. You can engage a third party to help you with that. You can do it under direction from counsel in an attempt to keep it privileged. The jury's out on whether or not that will actually do that, but there are ways to do pay audits that are very helpful. You need to take a look at your applications and make sure that we're pulling off any questions about pay history, that we're not asking people those things. So there's some just stuff that we can go through to kind of get our house in order and make sure that we're aware of what these laws are requiring. So since we've talked a lot about pay, let's talk about something that's brand new, cannabis in the workplace. A topic I never thought I would ever be talking about when I went to law school, or an area of law that I would ever thought I'd be practicing in, but it is the reality of the day. So why is this an issue and why are we talking about it? I'm sure anybody that's listening to us knows that we have seen an explosion in states for medical use statutes for using cannabis, and also for adult use. And I think we're going to see adult use even skyrocket, because in light of what's going on in our economy, states need tax revenue, and the thing that you can tax as high as you want, and people don't usually complain: cigarettes, alcohol, and why not cannabis? So there is a push there, so we might be seeing more of that. But I'm focusing right now just on the medical side. So what has happened for states where we've had medical statutes in place, authorizing statutes, what I call them? We've seen plaintiffs in that some of those states challenge a termination for a positive cannabis test. And the basic allegation supporting that claim is, I have a disability, meaning I have an underlying condition under the statute that allows me to get a recommendation for cannabis, to be treated with cannabis. And that is a treatment for that disability, and you are taking an adverse employment action against me based on that disability. And those claims either arise under a state anti-discrimination statute, or they can arise under the actual authorizing statute itself, depending on where we are. So the most important thing here is the state statutory language is what is going to control. Still illegal under federal law. We're not looking at the Americans with Disabilities Act. We're not looking at federal law on this. We're looking at state law. So it's really important to understand what your state statute says with respect to what's authorized and how it affects employers. And two, if you have law that's come out underneath your anti-discrimination statutes, then they also come into play. So let's talk about some of these cases. We can go to the next slide. I'm not going to get into a lot of detail about them, but I kind of put up the ones that we've seen here. I think the Barbudo decision is not on this slide, but it really was the first one that came out of Massachusetts. Most of the fact patterns here follow one of two things. One, I have a potential employee that has interviewed for a job. You give them a conditional offer, say, here's your conditional offer, you just have to pass a drug test. Potential employee says, oh, okay, that's fine. By the way, here's my medical marijuana card, my medical cannabis card. I'm going to test positive, just so you know. Somebody at the company says, that's fine, not a problem. They take the drug test, it comes back positive. And then somebody else in the company says, oh no, that is a problem, and we're going to terminate you, or we're going to revoke your offer. Or we have a situation where we have an employee that's working, there's an accident on site, they have to take a drug test to come back, they tell us that they are using medical cannabis to treat an underlying condition, they're going to fail, we say that's okay, somebody says that's okay, they take the drug test, they fail on the cannabis piece of it, and somebody else in the company says, no, that's not okay, and they get terminated and they file a lawsuit. So these three cases really talk about this. The Knopfsinger case is an interesting case because it came out of the District Court of Connecticut. So it came out of a federal court, not a state court, but it was relying on the state statute. Connecticut has a statute authorizing the use of medical cannabis. This is an individual who was hired, took a drug test, told them that she was using medical cannabis, tested positive for cannabis, and they revoked her job offer and she sued. The interesting thing about Knopfsinger is it was a federal contractor at play here, and they relied on the Drug-Free Workplace Act. And what the court in Knopfsinger said is, no, that's not sufficient because the Drug-Free Workplace Act does not require drug testing, and it doesn't deal with what you're doing outside, just as you can't be under the influence at work and using drugs at work. So it was an interesting take on that defense that we've seen a lot. And in Knopfsinger, they prevailed on a motion, they got past a motion to dismiss, and the plaintiff also prevailed on summary judgment and was awarded damages for those claims. Wild versus Carriage Funeral Homes, Funeral Holdings, that's the case in New Jersey that went all the way up to the Supreme Court. That was a funeral director who had gotten in an accident at work, a car accident, absolutely not his fault. Someone else hit him. He went to the emergency room. They wanted to test him. He told the emergency room doctor that he was a medical cannabis user. And the ER physician said, I do not believe you're under the influence. You're not impaired. You didn't do the drug test. The employer said you have to do it if you're going to come back. Does the drug test, comes back positive for cannabis, and then he's terminated. And that case is still pending, but on a motion to dismiss stage, they let them proceed with that case under the New Jersey law against discrimination because he was treating an underlying disability. In this case, he was receiving chemotherapy for a cancer diagnosis, and he was using medical cannabis to be a palliative treatment for his chemotherapy. The Palmer decision, so Pennsylvania is one of the states where we have a state statute that we haven't seen any cases out of yet. This is the first one that's come out of Pennsylvania. It is a state court trial decision, so it's not binding by any means on the other counties in Pennsylvania, but nevertheless, it has followed the same type of logic and reasoning as these other cases. So understanding, where these claims are coming from and why is really important, and they're looking at the state statutes for that. We can go to the next slide. Now, again, I kept saying, this is medical, right? Adult use is not the same as medical. And why is that? Because we're not in that whole reasonable accommodation space where somebody's receiving treatment for a disability. So it's not the same. The analysis is not the same. But the state statutes might create language that provides some protection depending on what those statutes say. But all of the reasonable accommodation, that kind of falls away because we're not really focused on that. Go to the next slide. So one of the key things also is, we don't have to, so what can we still do? We don't have to allow on-site use. We're dealing with off-site use to treat an underlying condition. We can prohibit employees from using cannabis during work hours. We can prohibit them from being under the influence in the workplace. So what does that mean? The challenge is going to be identifying what is under the influence or people that are impaired and how we train our managers and supervisors to do that. We can go to the next slide. There hasn't been a lot of stuff in any of the statutes or the cases about this, and I know that we're not in Illinois, but I put this slide up because I think it's very helpful. Illinois passed adult use as well as they have a medical program, and they actually defined in their statute some indications of impairment, which I think is very helpful when we're talking about recognizing that in our workforce. And they put together some of the symptoms that they've kind of characterized as influence of cannabis, even though we don't necessarily have that anywhere else. Physical dexterity, coordination, demeanor. So what that means to me is that when we're going to document someone because we believe that they're impaired, these are very good indicators that we could potentially use to document that we think that they're impaired. You can go to the next slide. So one of the, and on-site possession, same thing, right? We can prevent on-site possession. We don't have to allow people to have it on site, don't have to allow people to distribute or manufacture on site. This Hesh case was interesting. It just got filed in Pennsylvania. I'm not sure exactly where it is now. In this instance, a person was working, cleaning out as she alleges in the complaint, she was cleaning out her bag and throwing things away before she left. And in her bag, she had an empty box for medical cannabis that had some type of something in it. I don't know if it was like an edible or whatever it was. And she threw that box away at work. And somebody saw that in her garbage and they terminated her for that, saying that she had cannabis on site. So it's an interesting take on the question. I don't know what's going to happen with that case, but you know, there was a claim brought for that as well. So if we're going to do something like that, we should make sure that we firmly documented why we think somebody had something on site and why we think they may have been using it on site. And go to the next slide. So part and parcel to what I've been talking about all of this with cannabis is drug testing. So why is it an issue? We can go to the next slide. The reason it's an issue is because there is no acute intoxication test for cannabis. If we believe somebody is under the influence of alcohol, we have an acute intoxication test, right? We can give them a test and we can find out right there. We don't have that for drug testing or for cannabis. And the reason is because THC is stored differently in your body. It can hang around for a really long time when you're not impaired. And if somebody is consistently using cannabis legally underneath the state law to treat an underlying condition or as a palliative care, they're probably going to have THC in their system and they're always going to test positive. So the takeaway here is presence does not equal impairment. Just because you have a positive cannabis test does not mean somebody is impaired. So it's going to be very, very important to make sure that we are documenting impairment as well as a potential positive test if we go that route. And the other thing, one more thing I want to mention, we can go to the next slide, is we've seen a lot of states start to take some action on drug testing. And so the most recent state for that is New York City. You can go to the next slide. They have actually passed an ordinance in New York City that went into effect this year that prohibits drug testing for cannabis for job applicants. Now, are there exceptions? Absolutely. We've listed a lot of them there. They're the ones that you would think. Police, CDL drivers, people that supervise kids. There's a whole kind of section of folks there that they're accepted from that rule. CBAs are going to trump this as well. And if you suspect somebody's under influence, you can test them. But this really gets at the heart of the pre-employment drug screen. And we've seen a lot of stuff here because states are starting to pass adult use and they're kind of gearing up for that. Nevada also has a statute. There's been some discussion, but I wouldn't be surprised if we see more of that. So let's talk a little bit about the other thing on our list, which was paid sick leave. We want to go to the next slide. So that we've done pay equity, we've done, well, we haven't done cannabis, but we've talked about cannabis on this presentation. And so let's talk about paid sick leave. So paid sick leave, again, this is an area where we have seen complete inaction on the federal level. So the states are doing what the states want to do. And you know, that's good and bad. It creates quite the patchwork that we have to look at if we have employees in multiple states. So what is it? It's they're looking at ways to give earned sick leave or paid sick leave or some type of sick leave in addition to a PTO policy or a vacation policy. So these all look a little bit different, but I can go to the next slide. What they usually entail is some requirement about accrual or front loading PTO, meaning you can accrue 1 hour for every 30 hours worked, you can, or however you do that, or you can front load a specific amount. Now, most of these state laws require at least 40 hours, which is 5 days of paid sick leave. And they all will usually contain some type of prohibition or requirement for rollover. These use it or lose it policies, how much can you roll over, how much can you keep? And then they all talk about what's covered. And these things are going to differ from state to state in terms of how they do them. For those of you that have dealt with New Jersey's paid sick leave law, it is a bear. It has a lot of specifics in it that are difficult to follow. Some are much cleaner. Massachusetts has a nice law that's pretty easy to follow. But you have to look at what's covered as well, because it's not just because you're sick. They usually throw a bunch of other things in there as well. We can go to the next slide. So what we've included here on these next 2 slides are generally the reasons for paid sick leave that are covered. So the stuff that we would typically think of, right, for paid sick leave: care, treatment, recovery for mental or physical illness, health conditions, preventative care, doctor's appointments, things like that. They are also going to usually cover care for family members, or that the employee is responsible for caring for, usually treatment, recovery, mental health status, physical injury, preventative care. Those things we kind of understand that are going to be in there. You can go to the next slide. The other things that are a little bit different are time needed for an employee or a family member for a victim of domestic violence or sexual violence. Those used to be in separate statutes. A lot of those are being pulled into the paid sick leave statutes. Participation in civil or criminal proceedings with respect to those issues. So that's typically not something we would think that would be covered under a paid sick leave law, but there are statutes in states that do cover that. The second bullet here is one that most folks do miss. It's time for to go to your childcare, school, if they're closed because of some issue. You're also permitted to take time off if you need to attend a school-related conference. There's a whole kind of host of things that are covered there. But those are things that you should take a look at to see if you're required to provide leave for those. If you are, clearly we want to update policies. We'll make sure it's in our handbook and it's clear to the employees what they have notice of. So we can go to the next statute, or the next slide. Here, again, I'm not going to go through each of these specifically, but we tried to include some just basic information with respect to the states where we know you folks are, in terms of who has those laws and what they mean. So let's look at New York and New Jersey. New York, you accrue 1 hour for every 30 hours worked. New Jersey is a state where you can do accrual or you can front load, and it has rollover requirements. Again, Pennsylvania, Philadelphia only. It should be on its bumper sticker for some of these things. It has paid sick leave, but the rest of the state does not. And then we can take a look at the last kind of 3 that we focused, or last 2 that we focused on. Maryland and Connecticut, again, we see this accrual method. I will point out, Maryland, there is a threshold for the number of employees you have to have before you provide it. So depending on what state you are in, there may be a threshold level, but most of them don't have that. So the other thing is that most of these will apply to full-time and part-time. They just do a pro rata for part-time as opposed to the full-time folks. So for anyone that has employees in multiple states, I kind of say take the most restrictive and make sure you comply with it. And then you should be able to comply with everybody else's as well. But you have to be careful about whether or not you need specific notice requirements for your employees. So if we have employees in New York, New Jersey, and Pennsylvania that are working in Philadelphia, New Jersey has a specific notice form we had to provide our employees. New York has a specific notice form. So while we can have a policy that will be compliant with all of them, we do need to make sure that we provide the right notice to our employees at the time so that everybody is aware of it. So we've got a couple boxes to check when we're dealing with these statutes: the poster notices, the mail notices, the email notices, whatever we have to do to make sure our folks know what they're entitled to and they understand what they can take. So the last piece of my updates to state laws, and I'm going to call it Misclassification 1, deals primarily with independent contractors. So anybody that's, well, I don't know, maybe I'm just nerdy. Angela and I see it all the time because we read all of the headlines in the legal industry of all these cases that are popping up about independent contractors versus employees. It's been a big issue for companies like Lyft, Uber. I don't know if anybody saw it last week. They were threatening to pull out of California. California classified all their drivers as employees, and they worked something out and didn't do that. But it's definitely been an issue that's front and center. So we can go to the next slide. Let's just talk about, why does it matter? It matters because there are implications under the law for employees versus independent contractors, right? So somebody's W-2, somebody's 1099. Those things mean different stuff, right? So for employees, if someone's on our books as an employee, that means we're going to have to pay their taxes. We're going to have to cover their unemployment insurance, their workers' comp insurance. We're required to pay payroll taxes. We have to withhold federal income tax. We have Medicare tax. We have all of that stuff that goes along with it, right? And the most common reason this becomes an issue that I've seen that triggers some type of investigation by the State Department of Labor is we have a worker that went and filed a claim for workers' comp or for unemployment, and the state says you're not entitled to that because you weren't an employee, you didn't pay into the system. And that will sometimes trigger an audit where they come in and take a look at all of our people to figure out if we've properly classified them. So what do they do when they're trying to figure that out? We can go to the next slide. Figuring out if employees, or if a worker is an employee or an independent contractor, there's a whole bunch of different tests. This is looks like an eye chart, I know. And we're not going to go through all of them. But there's the DOL, which is the Department of Labor, the Federal Department of Labor, under the FLSA, which is the Fair Labor Standards Act. They do this economic reality test, and it's a multi-factor test that has a whole bunch of different things in it. They focus a lot on who controls who's doing this, who controls the work week, and it's very factually dependent. There's a common law test under the National Labor Relations Act, under ERISA. Also, multi-factor tests, very fact sensitive. The IRS, not to be left out, also has a test that they use. And then we have these state law tests. So the state law tests are the ones I want to focus on because that's where there seems to be a lot of activity lately and some issues. So the one at the bottom there was the ABC test. So this is New Jersey's ABC test. The ABC test is not the alphabet test. It is usually, it's in reference to the statute that typically says, you know, it's A, B, and C. That's kind of how it's laid out. This is a restrictive test. New Jersey has this. They use the ABC test for classifications of workers. And what it is there is a presumption that the worker is an employee. They are presumed to be an employee unless you, employer, can demonstrate all three of these things. That the employer has neither exercised control over the worker nor had the ability to exercise control in terms of the completion of work. And the services provided were either outside the usual course of business or performed outside of all the places of business of the enterprise, of the employer. And C, the individual has a profession that will plainly persist despite termination of the challenged relationship. So what does this mean? A, we can't exercise control over what they're doing on a daily basis. If you do, New Jersey's going to say you're probably your employee. That the services they provide are not in the context of what you usually do. If your business is to drive trucks and you have 20 independent contractors that drive your trucks, you might have a problem. If your business is to drive trucks and you have an independent contractor that comes in and does your IT services, that's where you might have a difference. So those are things that's what they're talking about. It's not something that you typically need to conduct your business. And then the third piece talks about whether that person will still have a livelihood if they don't work for you. Meaning, and usually, you know, part of this is we want to have an independent contractor relationship with another entity that provides services to other companies, not just us. I will tell you, in the state of New Jersey, the DOL audits that I have looked at, they will look at the 1099 incomes of the independent contractors and see what portion of that income comes from you. And if it's a 70% or higher, they will most likely find that they're your employee, not an independent contractor. So this test is very restrictive. We've seen it starting to be adopted in other states. I believe Connecticut follows the ABC test with respect to some of its wage payment laws. Maryland also uses the ABC test for certain services like construction and landscaping. So this is the most restrictive, and it's the most difficult to overcome when we're dealing with this issue. So let's talk a little bit about how do we avoid having these issues, because why is it a problem is if a worker is misclassified and the state comes in and says this person shouldn't have been an independent contractor, they're an employee. So do you know what that means? That means you get to go back and pay all your payroll taxes and all the things that you should have been paying for them beforehand, plus interest and penalties on top of it. So that's why there's an issue if it gets pointed out, a damages issue. It can create liability on wage and hour for overtime. So that's why we want to know and make sure that we've properly classified our employees as employees or independent contractors. So how do we avoid this issue? An internal audit is a great way to do it. Take a look at our people, how they're classified, make sure that, you know, if we're in New Jersey, Connecticut, Maryland, that we're looking at those tests to see if, hey, would we be able to pass this if somebody came in and looked at this? Do we need to make these folks employees so that we're not dealing with that issue? What are our policies and practices and our benefits programs for compliance? How are we keeping track of all of this on our end? And independent contractor agreements are really important. If you have an independent contractor based on a verbal understanding, I would really suggest that you consider putting that in writing. Having an independent contractor agreement itself is not sufficient to demonstrate they're an independent contractor, but it is extremely helpful because we're going to lay out in that agreement what their responsibilities are, what their duties are, what they do, and be aware of the things that, you know, the ABC test says we can't necessarily have. So let's talk a little bit about documents for misclassifications. Are our documents consistent with our contractor relationship? Do our handbooks apply to them? Are they subject to company rules? Do our independent contractor agreements look like employment agreements? Because if they do, we might have a bit of a problem later. So they can be helpful and hurtful. So we want to make sure that we're using language that's helpful, that's correct, and that really lays out what that relationship is. And just a word on non-compete agreements. Non-compete agreements get hairy if you put them in an independent contractor agreement, because remember that third part of the ABC test, that they have to be, that the individual or worker has to be providing services to other companies. If we have an agreement that says they're prohibited from doing that, that's not going to look great there. So think about what you need. Maybe you can protect what you need through confidentiality provisions, but non-competition agreements are definitely something to be on your radar if we're thinking about drafting these. So the next slide talks about what the consequences of misclassification are. And I usually tell everybody, if you really want to know, just take that pay stub, right? Take your pay stub and look in those withholdings, the little square with all the withholdings. Everything in there is a potential consequence of misclassification. It could be a back pay issue because of overtime. Benefits could be an issue because, hey, I should have been entitled to health insurance. I should have been entitled to vacation. I should have been entitled to all these things if I had been classified correctly. Disability payments, workers' compensation could be an issue. Tax and insurance, again, payroll taxes, whatever insurance you got. There are liquidated damages in a lot of these cases, and there are some civil monetary penalties that can also be at play, depending on what your state statute says. So that was kind of my highlight of things that we've been seeing on the state level. And I'm going to cede the floor to my colleague, Angela, to talk a little bit about some of the stuff we've seen on the federal level before we get into COVID-19.
Ruth, before we hand it off to Angela, we have a question that is relevant to what you just presented. And we have someone asking, so if someone tests positive during a random drug test given for all employees for, quote, drugs, and doesn't show, quote, impairment, then is it now not justification for termination of the employee? And before I let you answer that, Ruth, I want to set it up that this questioner is maybe asking it from the perspective of recreational as opposed to medical, but more importantly, and I'll let you handle that as the person answering the question, Ruth, but more importantly, in our industry, we have individuals, i.e. drivers, that are required under Federal Motor Carrier Safety Administration to be in a drug testing pool, and they cannot be under the influence of a Schedule 1 controlled dangerous substance. So what we have, so that's for your edification. I'm going to now reread the question because it might get into recreational versus medical. So if someone tests positive during a random test given for all employees for drugs and doesn't show impairment, then is it now not justification for termination of the employee?
Okay, so I'm going to try to answer that question and hit the highlights that you said. So it will matter if it is for medicinal purposes or for adult use. All of the drug testing that we've been talking about, if it's a random, whatever it is, if they test positive, and let me just start by, I'll use New Jersey's statute as an example. So under the expanded New Jersey medical statute, there's language in there specifically for what employers have to do. And it says you can do a drug test, you do a drug test. If you get a positive test back for cannabis, you have to give the employee the ability to explain the reason for that positive test. The employee can, and I think it's 3 days, you have to give them within 3 days, they can provide a response. And one of the explanations that's deemed acceptable under that statute is that they have a medical cannabis card and they provide that to you. And that will be, under the statutes drafted now, a reasonable explanation for that positive test. So I think to the first part, it does matter if it's adult use or medical. And if someone has a medical card, because that brings into play all of that stuff we were talking about with respect to underlying conditions and reasonable accommodations and that analysis. Adult use is separate. Adult use, you don't have an obligation to, if someone tests positive, not take an adverse action if they don't have authorization for medical cannabis. But you have to look at the state statutes, because of some of the state statutes that have been being passed are making exceptions to that, where you cannot discriminate or take adverse actions for positive drug tests. So there is a difference. The second piece I think that you raised, Eric, is if we have separate federal regulations at play that are controlling, they will control. And the exception that you pointed out, which is clearly different, is Department of Transportation guidelines. If there are specific rules from the federal government that require individuals pass drug tests, including cannabis, and they fail, regardless of whether they have a card or not, they're not going to be able to do that job if the federal regulation that we're relying on is specific about what that is. And usually Department of Transportation is one of those. Now, the other piece I would say is that when we're talking about safety sensitive positions, and it is for medical, they've given us the card. If we're going to take an adverse action, and we've looked at our state statute, you need to document some sense of impairment before we do that. And random drug tests are a whole nother can of worms. But I'm assuming that question came from federal regulations require random drug tests or random drug screens. This is what we do. And in that case, then yes, you would be able to do what you have the ability to do based on what the federal regulation says. I think I got all of that. Did I miss any of it, Eric?
You're perfect as always, Ruth. So now you can hand it off to Angela.
Okay, and with that, I'm done. I'm out. I answered my question. I'm good. No. So I'm gonna pass it off to Angela to talk about some of the federal changes we've seen.
So good morning, everyone. Can you hear me?
Yes.
I think that's good. Okay,
Yes.
Great. Terrific. Good morning, everyone. So as my colleague Ruth stated earlier, most of what we have seen as far as changes in the law, on the federal level is concerned, are related to COVID-19. It's at the top of health concerns, it's at the top of federal law changes, but there are a couple of other changes that we've seen on the federal level, and we're just going to briefly highlight what those are right now. And the two areas mainly are in the way of sex discrimination and what we're calling misclassification 2, which is a follow-up to what Ruth discussed concerning the first level of misclassification. So
and
first
Angela,
concerns.
here you advance the slides. I don't think they're moving on the presentation screen.
Okay.
Are they moving on your screen, Angela?
They are.
Oh, you know why? Hold on, that's my fault, as most things in life are. So hold on, I have to go to sharing, and I have to change it from Ruth. No, Angela, you should still be the presenter because you were the presenter before. So
Yeah, it says it's paused, and I'm pressing the button to unpause it, but it's not working.
okay, yeah, all right. So it's gotten hung up. Watch this. I'm going to take it away, and now I'm going to give it back to you, Angela, and let's just see if that kind of reboots it.
Okay.
Is it giving you the option to be the presenter?
No, it says no one sees my screen.
All right, I'm going to do it one more time.
Okay.
And then if need be, I have the presentation, so I will. So I'm going to make you the panelist, Angela, see if you got that indication from me.
Okay, and I'm going to click show my screen.
Yep.
Okay. Can you see the slideshow?
We are not, no, we are not seeing your screen. All right, so here's what we're going to do. I am going to take over and this classification 1. Let me just get to
You're on
Angela.
slide 34, I think, is where you need to go.
Yep.
Now you have to pay attention.
Yes.
Yeah, you know.
All right, hold on. Everyone, just bear with us one moment, please. I'm going to take back the presenter. I'm going to show my screen. I'm going to go to here, to slide 34. Current slide. Okay, do we see federal law?
We do.
Yes.
And here we are. Is this the screen you want, Angela? Federal law update? Or go to the next?
Yes, actually, you can go to the next one.
Sex discrimination?
Right, and actually the one after that. Yep, there we go. Okay.
Okay, you just say next and I'll advance. Thank you.
Okay, great, will do. Thanks for your patience, everyone. Gotta love modern technology, always something. So as I was saying, one of the first area we want to talk about as far as changes in federal law is a really major change in sex discrimination. And what we mean by that is, of course, Title VII prohibits discrimination on the basis of sex for any employment action or adverse employment action, and that's for promotions and raises, as well as hiring and firings. Well, there was a major decision by the US Supreme Court in June, which expands the definition or holds that the definition of sex in Title VII includes gender, includes sexual orientation and gender classification. And this is the first time. There are some states and some circuits that have previously held that, but this is the first time that the Supreme Court has firmly established that the definition of sex extends to that classification. And so the case is called Harris Funeral Homes versus EEOC. It was decided in June of this year and actually came by way of a group of 3 cases that were consolidated for oral argument. In the first case, it involved an employee who was fired shortly after informing her employer of her intent to transition from male to, or traditional male to traditional female. She brought a suit under Title VII, and the Sixth Circuit ruled in her favor. Case number 2 involved a skydiving instructor who was terminated after he told a patron that he was gay. And in that decision, the Sixth Circuit actually ruled in the employer's favor and held that that action was not covered or protected by Title VII. In the third case, similar to the second case, the 11th Circuit ruled in favor of the employer again, that Title VII did not protect a gay employee who was terminated after a colleague made a disparaging remark about the employee's sexual orientation and his participation in a gay softball league. All 3 of these cases turned on the same issue, which was the question of, does the phrase sex, or does the term sex as used in Title VII include an individual's sexual orientation or gender identity? Next slide, please. And so, as I said, the Supreme Court ruled not in a unanimous decision, but in a 6-3 opinion delivered by Judge Gorsuch, holding that the literal meaning of sex includes sexual orientation and gender identity, such that Title VII's prohibition of discrimination on the basis of sex will always include discrimination motivated by sexual orientation and transgender status. And the court summarized its opinion in a really clear, what I think is a clear comparison. The court said, consider for an example, an employer with 2 employees, both of whom are attracted to men. The 2 individuals are, to the employer's mind, materially identical in all respects, except that one is a man and the other is a woman. If the employer terminates the male employee for no other reason other than the fact that he's attracted to men, then the employer discriminates against him for traits or actions that it tolerates or allows in his female colleague. So stated differently, the employer intentionally singles out a single employee to terminate or to take an adverse action against based on the employee's sex. And the affected employee's sex is a but-for cause of his discharge. And that was the court's summary, which I think was really clear. And the court was very careful to note that it was not addressing other issues. For example, religious identity, principles based on political affiliations, wasn't extending its holding beyond that level, just saying that the definition of sex applies to sexual orientation and gender identity. And so what does that mean for employees? Next slide, please. So what that means for employers, many of you already have in your handbooks, in your written policies, or in your practices, a recognition that employers, managers, mid-level managers, and high-level cannot discriminate on the basis of sexual orientation or gender identity based on state laws or local laws. But this just gives an extra level of protection. As Ruth stated earlier, you have to make sure that you satisfy parameters on every level of the law, both at the federal, state, and local level. So if your state previously did not prohibit this discrimination and your policies did not so reflect, then you should update your policies to reflect what is now the federal standard. Other employers should review your equal employment opportunity policies and update them as necessary to ensure that you clearly prohibit discrimination on the basis of sexual orientation and gender identity. Likewise, managers should be trained to understand that discrimination on these new protected classes will not be tolerated. So again, even if it is not your written policy yet, it should be your written policy, and your managers should be trained and taught what that means exactly. So this is probably just the tip of the iceberg that we're seeing in this Supreme Court opinion. There are other issues surrounding sexual orientation and gender identity, such as the use of proper pronouns, he, him, his, she, her, hers, they, them. If you have an employee who prefers a certain untraditional or non-obvious pronoun usage, that is something that you want to be on the lookout for, that you want to make sure you respect the employee's wishes. There's also an issue or a question of unisex or gender neutral restrooms that so far there is not a federal law to address, but we may see more about that in the future. Next slide, please. So the second misclassification issue that we will talk about is the distinction between exempt employees versus non-exempt employees. Next slide, please. And what we know is this is one of those misclassification issues that often comes up. As Ruth pointed out earlier, the first misclassification issue is distinction between employee versus independent contractor. Here we're talking about distinction between two employees or two categories of employees, both of whom are employees, but are they exempt employees or are they non-exempt employees? Exempt employees, we know, are employees who are quote unquote exempt from being entitled to overtime pay. Non-exempt employees are entitled to overtime pay. So the Federal Labor Standards Act, we know that coverage for the Federal Labor Standards Act applies to employers based on your industry, based on your number of employees, and whether or not you engage in interstate commerce. For a lot of you, FLSA will apply, and if it does, under FLSA standards, covered employers must pay minimum wage and overtime to non-exempt employees. Next slide, please. So what does that mean exactly? Well, exempt workers are paid a straight guaranteed salary at a set salary level, regardless of how much time they work. So for example, if a person's salary is $50,000 per year, if they only work 25 hours a week, they still are entitled to that pay prorated salary for the week, whatever their annual salary level is. Next slide, please. So for non-exempt employees, I think you went one slide too far. There we go. So for non-exempt employees, generally, though they are paid for the amount of time that they actually work. For non-exempt employees or workers, the more time that they work, the more money they earn. And so for straight time, up to 40 hours in a week, and overtime would be any time that is over the 40 hours a week, and typically they would earn time and a half, or the hourly salary rate plus half. One word about non-competes, if you're considering non-competes for non-exempt employees, you might want to think about, in this context of classification or misclassification, that there is proposed legislation on the federal level to ban non-competes for non-exempt employees. Again, that's just proposed level at this point. It hasn't been passed. However, some states, in the absence of federal action so far, have proposed and or passed legislation of their own to ban non-competes for non-exempt employees. So you want to pay attention to what your state laws and local laws are doing in this area. And this is a great example of how what can be, or what should be, and usually has been a really straightforward issue, can affect different pieces of your business. So just make sure you have an understanding of that. Next slide, please. So how do we determine whether an employee is exempt from overtime or from an entitlement to overtime? There are three different factors that you want to consider. There's the salary basis test, the salary level test, and the employee's primary duties and whether or not those duties meet the requirements of one of the exemption categories as identified by FLSA. What you want to keep in mind is that these are not or salary basis test or this or that. These are 3 categories, all of which must be satisfied. So for salary basis, what does that mean? On a salary or fee basis, as opposed to hourly, that describes the rate at which the employee is paid. So to be paid on a salary basis means that the employee regularly receives the same pay for each pay period, whether that's on a weekly basis or a monthly basis, but it's a predetermined amount for their compensation. That's for salary basis. For salary level, that means that the employee is paid at a rate standard to the salary level, which is at this point, as of January 1, 2020, is $684 a year. And then you want to, again, make sure that the employee's primary duties meet the requirements of one of the exemption categories identified by FLSA, and that there are 3 major categories: executive, administrative, and professional. Those are the 3 major categories for exempt employees, and you want to make sure not just that their title falls under the category of executive, administrative, or professional, but that their actual duties on paper and in reality reflect that exemption category. Next slide, please. So there are a few new rules for salary levels that were passed or issued in September of last year and became effective as of January 1st of this year. Number 1, to qualify as an exempt executive, administrative, or professional, you must, in addition to meeting the current duties basis test. Yep, that's the right slide. In addition to meeting that test, you must be paid, as I said, on a salary basis of $684 per week. That comes out to $568 per year, and that just means that that's the minimum level that a person's salary has to be in order to be classified as an exempt employee. And just note that that is an increase from the past base level, which was just $455 a week, or $23,660 a year. Again, note that you must satisfy the minimum requirements on a federal and state level. And for those of you in Connecticut, note that the minimum for Connecticut employees is $475 a week. In New York, there's no threshold for professionals, but for executive and administrators in New York City, not necessarily New York State, but in New York City, the base level is $1,125 per week, and there are other thresholds for other counties in New York State. So you want to make sure that you are aware of what the levels are for your state and for your county. Next slide, please. So just a little bit more information about the salary basis test. Every employee must receive full salary for any week in which they perform work, regardless of the number of hours that they actually work in that week. So in other words, if you're an exempt employee and the standard full-time hours are 40 hours a week, if I only work 30 hours a week or 25 hours a week, you can't reduce my salary for that week to match the number of hours that I have worked. Again, just talking about the exempt category, it doesn't matter how many hours I work in that week. If I have worked in that week, I'm entitled to whatever my salary is for that week. There are some exemptions to that rule. We won't discuss that here, but just know that there are some exemptions at the federal and state level, so you want to be aware of those, but that's the basic rule. Next slide, please. So why are we talking about this? Why does it matter? Well, number one, it matters obviously because your employees want to be paid what they're entitled to based on their classification, but also because there are federal agencies that are very interested in this particular area of misclassification and have passed rules and regulations to so reflect. And that includes the Department of Labor. They have passed wage and hour, unpaid leave, and immigration rules and regulations that are based on an employee's classification as exempt or non-exempt. Also, the IRS, as Ruth pointed out earlier, if you look at your W-2 form and you see the different tax classifications, those are often dependent on whether an employee is classified as exempt or non-exempt. The EEOC, the rules and regulations and guidelines that the EEOC has issued regarding employment discrimination are concerned in some ways with how an employee is classified. And again, we want to be careful that we're not classifying based on a protected class. And the NLRB, the National Labor Relations Bureau, of course, the workers themselves, because they want to be paid what they're entitled to, Social Security benefits, and as we said earlier, the state and local agencies, all of these categories of persons are concerned with appropriate and correct classification. Next slide, please. And so specifically, the Department of Labor, as one of those agencies that is interested in making sure that workers are appropriately classified, they have issued enforcement and litigation guidelines based on these specific areas of industry with regard to classification as exempt or non-exempt workers. And that includes all of the categories on this list. Many of you would fall into either the construction industry, maybe the transportation and trucking industry, energy and utilities touches various different industries. And so you want to make sure that you are aware of the regulations and enforcement and litigation guidelines that touch each of these industries depending on your area of service. And so just a few words about best practices for proper classification. Thank you. For proper classification, number one, you might want to reclassify certain positions. And that would entail determining whether to maintain exempt status or reclassify positions as exempt or non-exempt. You would restructure a job. So if you reclassify, it's not just changing the job title or job position. You actually want to review the job descriptions and the duties that the person performs and make sure that they are properly classified. Timekeeping procedures. You want to make sure that for your both exempt and non-exempt categories of employees that you're keeping appropriate time. And you might want to consider implementing timekeeping procedures for all employees to make sure that your records appropriately reflect who is entitled to overtime and that they are being paid the overtime that they are entitled to. You want to make sure that you train your supervisors and managers to understand and know what classification each employee has so that they are in their timekeeping procedures and in their oversight of an employee's job duties and responsibilities, that they are staying in the appropriate parameters based on the employee's classification. And finally, employment relation or employee relation issues. Just a few questions that you might want to consider are: how will having more non-exempt employees impact workplace flexibility? Will employee morale be affected if exempt employees are reclassified as non-exempt? Will it be necessary to hire more employees in order to avoid incurring overtime costs? And to what extent do you want to communicate with employees about anticipated changes? These are all things that you want to consider and have appropriate guidelines and conversations with your managers and supervisors accordingly. And with that, now on to the topic that is perhaps the most interesting and what you've all been waiting for, employment law changes surrounding COVID-19. I'm going to turn it back over to my colleague Ruth to get us started in this section.
Thank you, Angela, and thank you for that update on the federal law. So COVID-19, has anybody heard about that? It's been all we've been talking about lately. So some of this is going to probably be repetitive about what you know. I'm not going to go through all of the specifics of the FFCRA, which I'll talk about in a second. The content is in these slides so that you have it as a resource. So you can go to the next slide. I get to tell Eric what to do. He has to listen to me for the next like 20 minutes too. So this is very exciting for me. Our disclaimer, look, this stuff is changing daily. For those of us that have been in the trenches on this since March on the employment issues, guidance changes every day. The laws are changing. Federal government is doing or not doing something. EEOC is doing something. So it is a topic that you need to stay on top of. We're going to present to you kind of the status of things as they are today. But it's really important that if you decide to make a change or do something, that you should really consult with counsel and make sure you have the most up-to-date information. So next slide. Biggie here on federal side, right? Families First Coronavirus Relief Act, the FFCRA. This was the first biggie that came out before we got to CARES. And I'm not going to cover CARES. That deals a lot more with funding and PPP loans and all that good stuff, which is a little bit above my practice area. I let our transactional tax people handle that and they can lose sleep over it. I lose sleep over the FFCRA. So what is it? It was enacted March 18th, 2020, effective April 1st, expires December 31st, 2020, which means it's a whole lot of new stuff we got to learn, a whole lot of new stuff we have to do, and then it all is going to go away in December. My guess is it is not all going to go away in December based on where we are pandemic-wise. There's most likely going to be some extension of this, would be my guess, but who knows? We shall see. What does it do? It includes mandatory paid sick leave in certain situations and paid family medical leave for covered employers. There are some tax credits on the back end of that, and it tries to stabilize the unemployment practice. So I'm sure we've all seen record unemployment numbers. We've seen those numbers pop up everywhere. So this was our federal government's first attempt to stop what was happening in the economy and provide relief to employers and employees. And we saw it under the FFCRA. The link that's in here, it's in here somewhere else as well. These are the FFCRA FAQs from the DOL. I think it's close to 100 now. This is an excellent resource. You know, it's so rare as an attorney when there's big statute gets passed and you don't know what any of it, you read it and you're waiting for guidance. So this guidance has been helpful. It is guidance. It is not a rule. It is not a regulation. It is guidance. But what does that mean for us as employers? It's the best thing we got right now. So it's what we're probably going to follow if we have a question. So that's the best place to start. So let's talk a little bit about what the FFCRA covers. So the next slide. Private sector employees with fewer than 500 people. You've got more than 500 folks, this does not apply to you. Not quite sure why they picked that, but that was the threshold they used. There are some caveats in here for people with fewer than 50 employees. You can be exempt from this if you can show certain extenuating circumstances where it would jeopardize your business. The final rule that came out provides some guidance on this. The frequently asked questions provide some guidance on this. It's still kind of, you know, searching through the fog a bit to figure out what exactly that means, because a lot of this we don't have decisional case law on, but there is a basis for that. There are exceptions for healthcare providers and emergency responders that can be excluded. The healthcare provider we'll talk about, they narrowed that exception, at least the Southern District of New York did, in terms of what that applies to. So we go to the next slide. So there's really two pieces of this thing, guys. We've got emergency paid sick leave and we've got emergency family medical leave. So emergency paid sick leave, 2 weeks, 80 hours paid sick time for full-time employees. We pro-rata that for part-timers. It's capped per day. There's a total difference depending on the reasons. There's a max cap on the dollar amount. So if it's a highly compensated employee, this is going to be the cap regardless. It's not what you would get if you were paid your regular rate. It's what you would get under the statute. But it's 80 hours of paid sick time. And we're looking to the FLSA, the Fair Labor Standards Act, to help us interpret this piece of the law. The second, and so let's talk a little bit about what that is. We can go to the next slide. So what are the covered reasons for paid sick leave? There are 6 reasons provided in this statute. All 6 of them have a whole bunch of questions associated with them that are answered in that FAQ and some of the final rule. So what are they? If an employee, and this means an employee is entitled to take the paid sick leave under FFCRA. The employee is subject to federal, state, or local quarantine or isolation order related to COVID-19. A lot of questions initially about what that was. Do general stay-at-home orders or stay-at-home recommendations count, or does it need to be an actual order that applies to that person? The general consensus and a lot of the FAQs that have come out and the rules are that the order has to apply to that individual, or at least be reasonably applied to that individual, and it has to be a requirement, right? Where there's some order that says you can't, you've got to be quarantined, you have to stay home. 2, the employee's been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. What are those concerns? Could be exposure, could be waiting for test results, could be a whole host of things. Again, a lot of answers in the FAQs on that. 3 is part and parcel to that. If you're trying to obtain a medical diagnosis or care, if you're experiencing symptoms. So, you know, this has popped up a couple times where, say, I have a fever, I have a cough, I'm out. So I have 3 days. I get my test. I can't get my test results back in a day. Shocking. Seems to be a problem in a lot of places right now, right? This delay. If I'm waiting for test results, the guidance so far has been that that's going to be covered paid leave, even if those test results come back negative, because you're trying to get that diagnosis. And again, we're going back to the reason we had this thing to begin with, was to try to qualify or cover that 14-day period to lower transmission rates and give relief to employers and employees. Next slide. Some of the other reasons are to care for a family member or to assist that family member for reasons that they might need sick leave for 1 through 3 above. So it can be you or it can be a family member. 5 and number 5 is going to overlap with the emergency family medical leave too, but to care for a child of an employee if their school or child care facility is closed or child care provider is unavailable due to coronavirus precautions. So this we saw a lot of at the beginning when daycares and schools were closed, if people needed time. If you have employees that are still eligible that have not taken this leave yet, you're probably going to see it again in September when schools are closed or schools are partially closed, or they might need time for that. So that's one that's going to be relevant to most of your employees. 6, if they're experiencing other substantially similar conditions specified by the Department of Health, Secretary of Health, and things like that. So really what we're looking at is 1 through 5 for the paid sick leave. So we can go to the next slide. The other piece of the FFCRA is we've got paid sick leave, emergency paid family medical leave. They're expanding, and what this was, just so that we're clear, this is a limited expansion, which I know is an oxymoron, but it is a limited expansion of family medical leave, and it's paid. So this is very similar to FMLA. However, there are changes to that in terms of, so you may not be covered by FMLA, you will be covered by the emergency family medical leave expansion in the FFCRA. It's available to employees of covered employers who have worked 30 days, not just the 12 months that you're required. So for that FMLA to kick in, we have some time periods in there that you have to work here. We're talking about 30 days. Whether you're a covered employee, you've got to look back at the statute to see if you satisfy the requirements there. They can't be able to telework because they need to care for an employee's child because of school or the place of child care is closed. So this last bullet point I'm sure you guys all just heard me say this for paid sick leave. This is an overlap, right? So it can be covered for paid sick leave and it can be covered for emergency family medical leave. That same situation applies when we're looking at child care. And it's going to continue to be an issue as we get into the school year for folks with employees with school-aged children. So we can go to the next slide. So what are you entitled to under the FMLA or the expanded family medical leave? So under the FMLA, the leave rights that you're going to get is 12 weeks. Now the difference between the FMLA and the expanded family medical leave is this is paid, right? So the first 10 days of this expanded family medical leave are going to be unpaid. However, the employee has the option to use the 80 hours that they've got under the paid sick leave. If it qualifies, they can basically fill in that whole 12 weeks. They don't have to. They can use accrued PTO if they want to as well. But you're going to get, then after the 10 days, that's when the EFMLA kicks in. Regular rate of, it's the employee must pay partial 2/3 regular rate up to $200 a day, maximum of $10,000 under this particular provision. So let's talk a little bit about these are addition to rights. And this was a question for a little bit, but these are in addition to. So we can go to the next slide. When this first came out, we had some questions about whether this was in addition to PTO that you already had, in addition to sick leave, or if you already have sick leave, does this count too? So why is this an issue? Remember when we talked about paid sick leave before? Not all states have it. So when the rules came out, or when the statute came out and the guidance came out, it wasn't really all that clear. And then new guidance was issued, and it's in the final rule as well, I believe, that the leave here is in addition to any paid leave rights under the employee's policy for state law. So what does that mean? If I have 40 hours of PTO or paid sick leave under New Jersey law, and I want to take my paid sick leave under FFCRA, that's on top of that. You can't run those concurrently. That's an additional 40. Now, the employee can elect to request to use their other paid leave to supplement the difference, right? So we've got this cap, right? So maybe the cap of what you get per day. Employee can make the choice to use some of my PTO to get me up to what I would have made before and kind of get rid of that bank as well. So there's some very sticky procedural pieces here that really require you to dig into it when we're dealing with what our employees can do. Next slide. So we finally got on April 1st a final rule. So we have this big statute with all these pronouncements and a lot of questions. And I know for anybody on the phone that was dealing with this, lawyers, not lawyers, you're pulling your hair out because it was brand new and we had to figure out what to do. And we were guessing a little bit in some situations. We got a temporary rule that came out, and then we got the final rule. And the DOL bypassed their traditional rulemaking and put this out. And it's very helpful, actually. A lot of the rules are very helpful. They get into the specifics of what you can and can't do. One of the things that they made a rule on was, what happens if the employer closes down their site because there's no work to do? And the person, because of a stay-at-home order, or because of some executive order, and the employees aren't working, are they entitled to the leave? What the final rule said is no. It's what the attorneys call a but-for causation test, meaning but for you have to show that the reason you are not working is because of this order. Whereas if there's no work to be done, that's why you're not working. So there was a distinction drawn there. Now, right after the final rule came out, the state of New York filed a lawsuit against the Department of Labor. And they challenged three primary interpretations of the FFCRA by the DOL. They said that they unlawfully narrowed eligibility for leave on three bases. One, the work availability requirement, which is what I just said, meaning this but-for kind of causation test. There was a really, really expansive definition of healthcare provider, which was not consistent with what was in the FMLA. Intermittent leave, there was an issue as to whether the employer had to provide that if requested, and if you want to take this on an intermittent basis, and documentation requirements, because one of the issues here is how do we document this leave if folks need it? What do we have to have them give us to demonstrate that they're taking leave? And the reason it's important to get the right documentation is because in the back end of this, we're able as an employer to take advantage of certain tax incentives if we can demonstrate our employees took paid leave. So the documentation piece is important for two reasons. One, that the leave is appropriate, and two, for the back end issue with respect to taxes. So the Southern District of New York actually issued a decision a couple of weeks ago invalidating portions of this rule. It's not a nationwide injunction. It doesn't talk about applying to other places, but it's out there. We haven't seen what the DOL is going to do yet. It might lead to other lawsuits, but I say that just because this is a issue that is ripe for challenges, and we're trying to kind of make our way through it. We can go to the next slide. Some of the state-specific COVID-19 issues that we're seeing, I just kind of wanted to highlight them because we've already been talking for a while. And things that you should look at specifically with respect to the states is, the government's doing these things, but the states are also working. I use the word in tandem loosely because it sometimes isn't in tandem. It's sometimes like straight loggerheads in terms of what one is saying, the other isn't. Some things that I wanted to point out: New York actually passed a quarantine leave law that deals specifically with quarantine issues. That came out a couple months ago, right when we got into this. New Jersey actually amended the paid sick leave law that we talked about before to cover COVID-related issues. And I'm sure for anybody that's seen the news, there are travel restrictions that have been issued by Pennsylvania, New York, New Jersey, Connecticut. New Jersey's travel restriction is still an advisory right now. New York and Connecticut actually have executive orders out there with respect to who has to quarantine when they come into the state. This can affect your employees if they are traveling for business, traveling for vacation, what they're doing and when they're coming back. So things to be aware of. We've seen a lot of action on WARN Act amendments. For those of you in New Jersey passed an amendment to WARN. They have suspended that going into effect until the governor ends the state of emergency. We've seen a lot of other states do similar things. And the reason being that, because a lot of businesses closed and a lot of employees may have been terminated or furloughed or laid off, whatever we want to call it, that would sometimes trigger a WARN obligation. And there's been some relaxation of what notice is required. We're starting to see lawsuits come out of that now. But
Ruth, let me interrupt you there, because we have an audience where some of them are warnable and others aren't. Could you just state what WARN is for the benefit of all of us?
Sure. WARN is the Worker Adjustment and Retraining Notification Act, I think is what it stands for. And essentially, the purpose of WARN is that if there's going to be a plant closing or a mass layoff, usually 50 or more employees, or 33% of your workforce if you're over 100, and you're going to do a mass layoff, it requires a notice provision, meaning I have to give you 60 days notice, 90 days notice, and tell you that your job is going to be gone and give you certain resources. You also have to notify the state that that's going to happen. There's a federal WARN statute, and then there are also state, so many WARN statutes are state-specific statutes. New Jersey has a quote-unquote mini WARN statute, but it's really a notification requirement. And if you don't satisfy the notice provisions, the reason it's significant is it can trigger a payment obligation for failing to provide proper notice. It could be some type of severance. I think it's one week, I can't remember exactly off the top of my head, but it could be 1 to 2 weeks for whatever you missed in terms of the notice. You have to pay for that. And there's also statutory damages and fee shifting. So it's a big deal. Usually 50 is our threshold. If we've got 50 or more employees, and we need to start paying attention, or 100 or more employees, depending on where we are. The new statutes change that, and the state statutes differ a little bit. So definitely something to be aware of if you're considering closing down or laying folks off. The numbers are going to be really important. The other issues that we've seen on the state level are reopening guidance. There's a ton of it. We're not going to cover that, but there's a lot of guidance about how you reopen and what you do. And the last one is mask orders, which has been all over the news, but understanding who has to provide the face covering, employer, employee, if they have to wear it, where they have to wear it, what they have to do. Those are all state-specific things that we want to talk about. Next slide. I know we're running short on time, but we're going to run through just a couple of quick things. Resource page, guys. If you have questions, we tried to put on one spot some websites that will be helpful to you. EEOC's website is great in terms of what accommodations you have to provide. They put out very specific guidance on COVID-19. The thicker questions for the DOL, excellent resource if you have questions about that. The CDC's website is slightly overwhelming when you go to it, and you will go, oh, there's so much stuff on here. But if you take a minute and look at it, it provides some really helpful guidance, specifically with respect to how you reopen, who you have to notify of what, and how you do all of that. And then I included our website. We have a COVID-19 response page that you can go to and look for resources and things. Because this is not just employment related, right? This is leases, this is all sorts of stuff. So we have a lot of that there. And with that, I'm gonna just let Angela cover some of the just issues quickly that we've seen coming up with respect to returning to work, to the extent that any of you all are dealing with this. So I give it back to you, Angela.
Thanks, Ruth. So again, as we said, we're running really short on time, and I see that Eric has let you all know that you will be provided the PowerPoint presentation after this is over. So I'm just going to say on a really high level what each of these slides is concerning. So by way of accommodations, just note that the ADA, just like there are accommodations that you would have to make for every other disability, there are certain accommodations that may be required for folks who are very highly sensitive in that high risk category for contracting COVID-19. So just know that you might have some of those, you might have to make those accommodations. For next slide, for PPE, personal protective equipment, note that it is the employer's responsibility under OSHA standards to determine what type of PPE is needed for your workplace, and in certain circumstances to provide that PPE. And then under other circumstances, even if OSHA does not specifically require certain PPE, you might be required to provide it by way of state orders. And the number one thing on that list is face coverings or masks, which is not categorized as PPE by OSHA, but is categorized by as PPE by some states. Next slide. You want to have a comprehensive reopening plan. There are a lot of states have put out very, very detailed guidelines as to what types of safety measures you have to take when you reopen. A lot of those guidelines are industry specific. So for example, restaurants, schools, bars, etc., hotels. There are a lot of safety measures that are specific to your industry category, so make sure you know what those are. Make sure that you have trained your staff, your managers and supervisors to appropriately implement those safety measures. And a lot of state guidelines actually have training and monitoring as a part of the guidelines, so make sure you know what those are. And again, just a couple of websites here for resources. The CDC website, very, very helpful. The Saul Ewing website, very, very helpful. So make sure you make note of those. Next slide. This gives just a little bit more information about recommendations for your comprehensive reopening plan. And you can review those in more detail on the resource pages that we have provided. You also want to, there are very specific guidelines about what you can ask your employees and what you can ask your visitors by way of ensuring that they are not symptomatic of COVID-19 before they enter your establishment. Generally speaking, you are allowed to take temperatures. Generally speaking, you are allowed to ask what types of symptoms they may have, but that is very specific to what the CDC has identified as symptoms for COVID-19: fever, cough, trouble breathing, so on and so forth. Next slide. I already touched on temperature check. You can check the EEOC website to determine more guidelines with regard to temperature check. Next slide. This is a really important one, I think, because a lot of employers and a lot of establishments, the first thing when you're thinking about avoiding litigation, when you're thinking about mounting a best defense, a lot of folks try to have a waiver, have either their employees sign a waiver or visitors or customers sign a waiver saying that if I contract COVID-19 in this establishment, I will not sue you. You should note that a lot of courts don't like those waivers and will not enforce them. So they're not a complete 100% safeguard to future litigation or liability. They may be helpful in identifying that a person has taken on certain risks by entering your establishment, but they're not a complete 100% safeguard to liability. I just want to make sure you make note of that. And I think we're done. Ruth, you want to close us out?
Yes, so thank you. Thank you all for hanging with us. I know that was a lot for an hour and a half, and we're going to pretend like we didn't go over the hour and a half.
Well, you're not done, Ruth and Angela, because we have quite a few questions. So
okay.
just continue. I don't want people logging off because we have more for you, but continue with your little speech.
Oh, no, I just want to say thanks for everyone. My little speech. This is our long hour and a half speech. No, we can go ahead and take questions, and I'll save my thank yous for later for the folks who still want to hang out.
Okay. Some housekeeping here. The slides will be made available to everyone that has registered. Obviously, if you're on here, you've registered, we'll send it out to you. This program will be is being recorded and will be hosted on the Eastern Energy Expo website for the next week, and then we'll move to the YouTube channel in perpetuity of the universe afterwards. There was a comment made that HVAC contractors in Connecticut actually have passed the ABC test there as it relates to an oil dealer subbing out their some HVAC work. So that is very positive. That is troublesome in New Jersey because in New Jersey, the Department of Labor interprets the B prong as anywhere that the contractor does work is the place of business. That's the bad news. The good news is that the courts in New Jersey continue to beat up the Department of Labor on that interpretation. The bad news is, though, you've got to take it to court to get there, and that's expensive to get it to the appellate division. I give that as background to the next question, which is, can a CDL driver be legally classified as an exempt employee, knowing that seasonally they will work extended hours in the winter and minimal hours during the off season? So this is not a question about laying them off. This is a question about making a CDL driver an exempt employee as opposed to an hourly employee, because there's a difference in the volume of work between the winter and the summer. So ladies, first question.
Do you want to go ahead, Angela, or you want me to go ahead?
You can go.
Okay, so I'm going to start out with it depends. So to go back to what Angela covered, salary basis, salary level, and duties, right? So salary basis, are they paid the same salary on a regular basis? Salary level, are we meeting that threshold? And then the duties test. And if you're satisfying all three of those, then yeah, you can classify them as exempt. So you know, I don't know if I can answer based on the volume of work. I think it just depends on, I would imagine, on the duties test for them, if they're satisfying one of those exemption categories. And as long as we're hitting those threshold requirements, then yeah, they could be. But look, once somebody can satisfy a duties test, the duties test, and if they fall below the threshold level, that makes them non-exempt. So you just have to keep in mind it's all three of those things when you're looking at them and how you classify folks.
Okay.
I would just add to that to make sure that whatever criteria you're setting, that it's not based on a protected class, and that you're applying that standard evenly across all categories of employees who hit on whatever the standard is, whatever the criteria is that you're setting for the exempt or non-exempt status.
Thank you. Regarding sexual discrimination and LGB, let me start that over. Regarding sexual discrimination and LGBTQ protections, what is your recommendation for use of pronouns in a company policy book? He, she, or he, she, they?
So there really is no rule or guideline or law saying that you have to do one way or the other. To be safe, it's probably best to use they. At this point, as I said, the law is shifting. This is one of those evolving areas of the law where there are a lot more issues than there are case law and rules to address those issues. But we see a lot more rules being issued in this category. And so to follow the trend that we see the law going in, the best practice would probably be to use the gender neutral pronouns of they, them, and their.
Thank you. Can an employer, I'm sorry, my eyes are getting, can an employer require employees to take PTO before being laid off for COVID reasons or lack of work?
You require an employee to take PTO before, so I think it's a couple questions, being laid off or for COVID.
For COVID reasons or for lack of work. So there's two questions there.
Yeah, all right. So yeah, there's two questions. So let's take the first one, right? And we've dealt with this a couple different ways because these questions came in whenever all this was going on. Is if we're going to lay everybody off as opposed to terminate them because we're shutting down, right? What do we want to do? Do we want to make them use their PTO and pay them? Do we want to not pay them? Let them go make an application for unemployment? Because New Jersey, there's a, if you get knocked down at, like, I think it's 20%, you have eligibility. So that's an initial decision you have to make. And one of the things that depends on is, what does your policy say about PTO? And one way we have dealt with that for some clients is we said, okay, well, let's amend our policy, if it doesn't already say it, to say that we can require employees run their PTO while they're out. So you have to go back and look at what your policy says. When we're talking, and you can amend it, right? So policies can be, as long as we're not violating the law. So that takes me to my second point. When we say for COVID-19 reasons, what does that mean? If it is for the employees, one of the qualifying factors under the FFCRA for either paid sick leave or for emergency paid family leave, and they're taking the leave for one of those reasons, and that could be a COVID-19 reason, one of those reasons, you can't make them use their PTO. That is a separate leave that they are entitled to under the FFCRA, the paid sick leave or the emergency family medical leave. On the emergency family medical leave side, the first 10 days of that leave are unpaid. The employee has the option to use their PTO for those first 2 weeks if they want to. That's they can do that. Or they can use the paid sick leave under FFCRA if they qualify. And we talked about those reasons. There's that one overlapping reason that might qualify. So it's kind of this confluence of all of these things. If it's for a COVID-19 reason, you really have to look at, is it specific to the employee? Is there something under FCRA, the FFCRA, that applies? And if it does, we can't, that's in addition to, right? That's in addition to PTO. We can't require them to use something else before they use that leave. If we're looking at it, FFCRA is out of the picture, paid sick leave law under our state, what does it say? Does it cover it? New Jersey amended its statute to cover it. So then they would be using their paid sick leave there. But it depends on what your policy says about what you can tell people when people have to use PTO or not. And if people are going to be furloughed, we have worked with clients to say, okay, let's have them use up their PTO while they're furloughed, then they come back, and then we'll do it that way. But you've got to look at what your policy is to be able to do that. So that was a convoluted answer to a complicated question, but there are a lot of places we have to look to make sure we're doing what we have the ability to do.
That convoluted answer will be the last answer to any question because that is the last question. So Ruth and Angela, the floor is yours to wrap up.
Well, I'll just say thank you guys thank you, Eric, for giving us the opportunity to speak with everybody today. It's always nice to do these, although I much prefer to be in person. I guess I'll deal with the Zoom or whatever it is for now. And we appreciate the opportunity to talk with all of you. And Angela, if you wanted to say anything.
Ditto with what Ruth said. Thank you, Eric, for the invitation. Thank you all for attending. Stay safe, stay healthy and well.
And I thank all of you for joining us and staying with us. This was lengthy because there's a lot to cover, and I urge all of you, regardless of what state you're in, to go back and look to see how each of these individual state matters are specifically playing out in your state. This was an excellent overview of thematically what is happening, and Ruth and Angela gave us at the state level some very specific things that are happening in individual states. Again, we will send this presentation to everyone, and the video will be posted to the Eastern Energy Expo website and then moved next week to our YouTube channel. Reminder that at 10 a.m. tomorrow morning, our program is Stop Being in the Energy Business, Get in the Customer Service Business. And we look forward to seeing all of you at 10 a.m. tomorrow. And don't forget that we have added a panel for Monday morning, the 31st. It's a 2-hour panel. It's called COVID and K-Factor, what heating oil and propane dealers need to do now. Thank you so much. We'll see you tomorrow morning.